After you have considered all of the ethical issues confronting your client and your law firm regarding the matter that your client has come and asked advice for, you will want to move on to discuss actually the legal options that are available to your client. When discussing those legal options, keep in mind that this discussion and the purpose and goal is to find all options available. In other words, it is a very broad undertaking in which you consider everything that the client could opt to do under the circumstances. Keep in mind that though it is very tempting as counsel to try to give an option that you feel is best for the client, that is not your purpose in generating these options. In the infographic that has been made available together with this video, you will see that in general you can give your client three types of options. Options that involve a court and court proceedings, an option that involves a non or out of court proceeding, and options not to take action at all. In each case, as is depicted in that infographic, you must consider financial, relationship, and time aspects for each of those options. In other words, if a client were to go to court, advise them of how that decision could impact, for example, their finances. What are the fees involved for courts and for having attorneys? You can also tell them about the timing. How long does it take for this transaction to occur or for the proceedings from start to end? And also, what kind of impact could it have on their relationships at work or at home? These three aspects can be talked about in each of the options, so you must do some research into that information. Check for information about filing fees in various jurisdictions. See what it is that the average lawyer might charge for those types of services. Check in to see how much it costs for alternative dispute resolution proceedings. This information will be very important for you to communicate to your client as you present those options.